Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We are continuing to evaluate records from the case styled as State of Idaho versus Brian C. Kohberger. And today I would like to direct your attention to an amended non-dissemination order that was entered by Judge Megan E. Marshall on January 18th, 2023. Now, you will recall that approximately 2 weeks earlier from that date, that Judge Marshall entered an initial non-dissemination order, or a gag order in my opinion, that prevented basically 3 groups of parties from making any comments about the case except to quote, for example, from the public record, any of the filings that appear on the docket. They can't go out and comment about the case any further. And the groups that were covered in that initial non-dissemination order were the attorneys for either side, investigators, law enforcement official. On the 18th, this amended order was more expansive. Now, first, what is an amended order? An amended order, because it's an amended non-dissemination order, amends or takes the place of the original non-dissemination order. So the first non-dissemination order is now rendered null and void. This order is now effective, and it states at the end that it is in full force and effect until such time that it is amended again or it is removed. Judge Marshall goes into a lot more detail here regarding the acts that are prohibited. She states, for example, that none of the parties covered under this amended order can make any comments about guilt or innocence of Mr. Kohberger, and there are other things that are specifically cited. But on page 1 of this amended order, we see that it is a lot more expansive in terms of who is covered, who is, in my opinion, gagged from making out-of-court statements. And that would be now witnesses, victims, family members of victims, attorneys to witnesses, and also attorneys to any of the family members or victims, in addition to the parties and to the attorneys involved, law enforcement investigators. In my opinion, the court also is reminding the parties that if they violate the terms of this non-dissemination order by way of a statement that is made at the end, that they could be held in contempt of court. She is basically telling them that you will abide by these directives. And what is contempt of court? Contempt of court is where a party is directed to do something or is told to refrain from doing something. In this case, they are refrained from making out-of-court statements about anything but quoting basically from the docket. And if they violate what the judge has told them to do or not do, there could be contempt of court. They would then be typically brought in. There's an order to show cause so that they're given due process. They have an opportunity to be heard before the court would impose any penalties. And in some cases, in the cases that I've looked at, those penalties could be fines, could be an admonishment, or it could also be incarceration. So when a court enters an order and tells someone that you will do or not do something, those parties, in my opinion, really have to take care and make sure that they are not directly or indirectly violating the order. And this court has language in here that says it can't be direct or indirect, but it must be deliberate. That means they must intend to violate the order. To see the non-dissemination amended order, please go to the description of this podcast where I provide you with instructions of how you can obtain this document. For now, thank you for joining us. Please join us again.